Good morning, everyone. Join Jackie Mondays at 10. And today's topic is learning who can make a claim against your will. So a lot of myths around this one, and I have done a couple of videos on this in the last couple of years before. But for those of you who don't know the updates, the laws changed in about 2015. So it used to be open slather on wills in Victoria, and that's why there are so many horror stories around claiming against wills, but it's tightened up so you can not worry so much anymore. So there's two ways that people can claim against a will. The first is based on its validity. So if they think that the person had lost capacity when they made their will and it's not valid, if it wasn't signed correctly, if there were other legal technicalities, or if the person was under undue influence, some validity issues could arise. It's really hard to make that sort of claim. The second type of claim is a family provision claim, which is much more regular, more likely. So a family provision claim is when someone says, I haven't had enough out of the will, like I haven't been provided with enough. They may have completely been written out. They may have just been given a token, or they may just feel like, 10%, 25%, whatever it is not sufficient. So that's a family provision claim. Now, family provision claims can only be made by certain eligible people. So this is what we're learning about today. So who is eligible? It's not open slather anymore, as I said. So it's not the neighbour down the street who has helped with the shopping. It's not the carer who has been in the house caring for the person for the last couple of years while they have dementia. It is not the grandchildren. It is not the nephews and nieces or the brothers and sisters or even parents. Parents cannot make a claim against their child's will. The only people eligible to make a claim against a will for family provision are a spouse who has been left out or not provided for. That can include de factos. They have to prove they're a de facto, of course. Children, including stepchildren. Potentially foster children, but more likely not if they're no longer financially dependent. And not children who have been adopted out. So spouses, children, and people who are financially dependent. That's pretty much it. That's pretty much it. Okay, so if you meet your moral obligation to those people in your life, no one else can make a claim against your will. And if you do want to leave those people out who are eligible, come and do your estate planning properly, speak to us, and we'll help you. Prior planning prevents poor performance. So we want to do it and do it right, and hope that there's not a mess later on. So I hope that helps. If this is valuable and you think someone else could use the information, by all means, please tag their name in the comments or share it with them privately on Messenger. While this video is posted today for Join Jackie, it will go into the vault of all the other videos on Facebook, and there's hundreds now. So it's a great place to start. If you or a family member or a friend have a problem, jump on to the videos tab on our Facebook page and scroll through and see if we've already touched on that topic. If we haven't touched on the topic, please contact us. You can see the email address above. My personal email address is jackie@tbalaw.com.au. Super simple. I can then address your question in a future Join Jackie. So have a great week, and I'll catch you next week.